In the prior section, we covered systems inside the home, HVAC plumbing pool, electrical permits, and safety features. Now we move outward into infrastructure and environmental exposure. Pages 6 and 7 of the SPDS shift from what's inside the walls to how does this property function in the world around it. Utilities, sewer, septic, alternate power, environmental conditions, and surrounding nuisances directly affect financing, insurability, buyer comfort, and statutory compliance. In Arizona, especially in rural, semi-rural, and expanding metro areas, these disclosures can determine whether a transaction closes smoothly or collapses during due diligence. Utilities and services, who provides what and why it matters in contract writing. The SPDS asks whether the property receives cable, electricity, fire service, flood, irrigation, fuel, garbage, internet, telephone, and water, and it requires identification of the provider. This may seem administrative, but in contract practice it affects buyer verification, lender underwriting, and cost expectations. Phoenix Metro. Example, a buyer assumes municipal water and sewer. During inspection period, they discover the home is on hauled water or a private water company with higher rates. That becomes a renegotiation point if expectations were not set early. Water source disclosure is critical. The form distinguishes public water, private water company, hauled water, private well, or shared well. If the property uses a private or shared well, the domestic water well, water use addendum must be completed. This is not optional paperwork. It directly ties into statutory water disclosure requirements and buyer investigation rights. Drinking water problems must be disclosed if known. If a seller is aware of contamination, quality issues, or prior treatment recommendations, non-disclosure may create civil liability. Fuel and propane. Owned versus leased. The repeating contract pattern. If the property uses propane and the tank is leased, that lease must be disclosed and attached if available. This mirrors the earlier sections on leased solar, security, and water treatment systems. In contract writing education, students must recognize the pattern. Leased systems create contractual obligations that must be addressed in the purchase agreement. Rural Arizona. Example, a property in Pinal County has a leased propane tank with a minimum usage contract. If the buyer does not agree to assume it, the seller may need to remove or pay termination fees. Disclosure allows the contract to allocate responsibility clearly. Alternate power systems. Solar wind generators. The Arizona reality. Arizona has one of the highest solar adoption rates in the country. The SPDS asks whether alternate power systems exist, whether there are problems, and whether any are leased. This connects directly to valuation, financing, lien priority, and title review. Gilbert example. A seller has leased solar panels with a 20-year agreement. Buyer's lender requires solar documentation for underwriting. If not disclosed early, closing may be delayed while escrow obtains lease details and payoff figures. If there are known problems, inverter failure, roof penetrations, production issues, they must be disclosed. Students should connect this to earlier discussions on written authorization and documentation. Solar disclosure is not marketing. It is risk allocation. Sewer and wastewater treatment. Public sewer versus septic. The inspection trigger. The SPDS asks whether the property is connected to sewer, whether a professional verified the connection, whether there is a lift pump, and whether there are known sewer problems. It then transitions into septic and on-site wastewater treatment facilities. Arizona practice point. If the property is served by a septic system, Arizona Department of Environmental Quality requires a pre-transfer inspection for resale properties. This is a statutory compliance issue, not a negotiable preference. Failure to comply can delay closing and create post-closing enforcement risk. Queen Creek. Example. A home on septic has not been pumped or inspected in years. Buyer discovers this late in escrow. If disclosed early with approximate inspection and pumping dates, the buyer can schedule required inspection within contract timelines. Alternative systems and maintenance contracts must be disclosed. If the septic is an alternative system under maintenance contract, that contract and provider details matter because ongoing service is often required by regulation. Repairs or alterations to the facility must also be disclosed. Septic repairs are expensive, and buyers need context to evaluate long-term risk. Environmental information: soil drainage fissures and neighborhood impacts. The SPDS then moves into environmental exposure. This includes soil settlement, drainage or grade issues, erosion, fissures, dampness, and nearby environmental concerns. In Arizona, expansive soils and earth fissures are real geological considerations. Mesa. Example: a seller knows of recurring drainage pooling near the foundation during monsoon season. If not disclosed, a buyer may discover moisture intrusion after closing and allege non-disclosure. The form references Arizona Department of Real Estate earth fissure maps. While sellers are not required to conduct independent geological studies, if they are aware of fissures or soil movement issues affecting the property, they must disclose known material facts. Noise nuisances and surrounding conditions. The livability disclosure: airport noise, traffic noise, rail line noise, landfill proximity, odors, sand and gravel operations, or other nuisances must be disclosed if known. These are not cosmetic details. They affect property enjoyment and market value. Scottsdale example: a home is in close proximity to a private airport flight path. Buyers unfamiliar with the area rely on seller disclosures to set expectations. If known and not disclosed, this can lead to dissatisfaction and potential claims. Clandestine drug laboratory disclosure and airport vicinity. The SPDS specifically asks about prior use as a clandestine drug laboratory. This is a high liability issue due to contamination concerns. If known, disclosure is mandatory. Additionally, the form asks about proximity to airports. Buyers may evaluate noise, safety, and future development differently based on that disclosure. These questions connect directly to the earlier seller disclosure advisory language you studied. Non-disclosure of known material facts can be treated as equivalent to misrepresentation in certain circumstances. Contract writing, integration, utilities, and infrastructure. From a contract writing perspective, these pages affect contingency planning. If the property is on septic, buyers must schedule ADIQ-compliant inspections. If on a shared well, buyers must review shared well agreements. If alternate power is leased, buyers must evaluate lease assumption or payoff. If environmental conditions exist, buyers may order specialized inspections. Your role as an Arizona licensee is not to engineer solutions or give legal advice, but to ensure disclosures are complete, attached documents are included when available, and contract timelines align with investigation needs. Transparency reduces renegotiation shock. Course discussions with answers. Discussion. Question: why does identifying the water source matter in Arizona transactions? Answer: because water source affects cost, availability, financing, inspection requirements, and sometimes statutory addenda such as well disclosures, and buyers rely on accurate identification to evaluate long-term usability and expense. Discussion. Question: if a property has leased solar panels and the seller does not disclose the lease until escrow, what risks arise? Answer: closing delays, lender underwriting issues, title complications, renegotiation over payoff or assumption, and potential breach claims if the contract did not allocate responsibility clearly. Discussion question: why is septic disclosure more than just checking a box in Arizona? Answer: because ADEC requires pre-transfer inspection on resale properties, maintenance contracts may be mandatory for alternative systems, and failure to coordinate inspection timelines can delay or jeopardize closing.